Gina Smith versus Shane Smith.
For the record, that this matter is before the court on the plaintiff's motion for to show cause, as well as the defendant's motion, emergency motion for sole legal custody, essentially modification of custody, as well as to suspend plaintiff mother's parenting time. This hearing is being conducted via Zoom. Present is Attorney James Petrangelo, representing the plaintiff mother, Regina Smith. Ms. Smith is present. In addition, Attorney Teresa Ouellette is present, representing the defendant father, Shane Smith, and Mr. Smith is present with Mr. Ouellette. Good afternoon, everyone.
Good afternoon.
Good afternoon.
Before we begin, the court would note for the record that this court did enter an order to show cause on February 29th, directing the parties to comply with the order of this court regarding parenting time and for the defendant father to return the minor child to the mother and appear on this date. Within a couple of hours after signing that order, the court received an ex parte order from Attorney Ouellette on behalf of Mr. Smith, suspending mother's parenting time, but the court had already set this matter for hearing, so the court did not take any action on the defendant's request for an ex parte relief. Both having been received within hours of each other. Anyway, the parties have conferred with Mr. Pratt this afternoon. Mr. Pratt has recommended the current parenting time remain in full force and effect. The court recalls Dad has parenting time every weekend, Friday 5 to Sunday at 5. Also noted that not only father, but also mother have violated the orders of this court regarding parenting time. There's no question the parties are taking things in their own hands. Mr. Pratt, have you received a copy of the defendant's response to the plaintiff's motion? There is attached to it a number of CPS law enforcement reports.
Yes, Your Honor.
Okay, the court went through all of those, and obviously there's concern, we say to everyone, on protective services, law enforcement on the mother's conduct, making particularly, the court would agree, Mr. Petrangelo, these go, most of these date back to prior to the last order of this court of July 18th, 2023, but the court was sort of somewhat taken back by repeated unsubstantiated complaints of child abuse on the part made by Ms. Smith. The daughter of the parties that went through same exams within 3 months.
3 same
I know we
exams.
just set this matter for a hearing. I just want to make sure the front of the court's aware of all that. Protective Services never sought to petition this court or file a complaint against Ms. Smith. Why, I don't know, with that kind of history. But the most recent complaint that was made by a mother in January of 2024. And that report was made to Westland Police Department as well as Protective Services. Does anyone know the status of the January 2024 incidents reports by mother?
To my knowledge, no formal action has been taken toward either party.
The hearing opens with a request that immediately changes the usual courtroom dynamic. Instead of arguing over missed exchanges or scheduling conflicts, the father's strategy targets something much deeper, the credibility behind repeated abuse claims.
Okay, so it's still pending as far as you know, Mr. Petrangelo?
Well, I suppose it's a question. If no action is being taken, I don't know if anybody's acting on it. I've seen no reports of any recent activity from law enforcement.
Okay. Mr. Petrangelo, did you receive a copy of the defendant's response to your motion and all the attachments?
I did.
I don't know if those were provided just to the court or if the other party received those, and Ms. LaPrade received those. Obviously, Ms. LaPrade, her office received those.
Yes, sir.
We received it.
All right.
And the court would note that mom filed a police report against dad as late as February 6th, claiming an occurrence occurred on February 3rd again, with again a false allegation. And according, we just received the report today, that again, Westland Police they're going to close the case because it's yet again another false allegation of sexual abuse against dad.
Right. Mr. Petrangelo, is Ms. Smith still being assessed by a psychiatric nurse practitioner by the name of Patricia Tiemann. Do you know?
I know my client attends counseling. I'm not sure if that's something different. Ms. Smith, do you know who the judge is referring to?
She is retired. She retired a few months ago.
So are you still seeing her for any reason?
No, in October, I believe, of 22 is when I started getting on antidepressants with when I was seeing her, but I no longer see her.
That was a year and a half ago.
Yes.
Okay.
Well, the reason the court's asking, thank you, Mr. Franco, is the court believes that Ms. Smith should not to be evaluated. And she previously saw a nurse, a psychiatric nurse practitioner, so somebody at that level that can do an assessment. Of course, somewhat shocked these allegations had come before the court prior. I know where the parties were back in this court in 2023, but the reports that Ms. Oletis provided the court never came to the court's attention in the past. And court, if the court's going to follow this recommendation today, the court's going to add to it. The court wants a psychological evaluation of Ms. Smith.
Well, Your Honor, if you're going to order psychological evaluations, they should be done of each party. I would say, Your Honor, in this case, everything that's been raised with the except in the last few weeks is all related to prior to your last order. These the parties met with CPS. They haven't seen fit to take action against either. Their letter that I attached dated February 15th said the parties should follow the current parenting time order of this court. So CPS saw no emergency, saw no urgency. And what did my client do? She followed what CPS said. What did Mr. Smith do? He took the children, refused to return them, pulled them out of school, which is in the effect of telling the kids, don't you dare ever report anything I do, or I'll put you somewhere where you can't get any help. You have no counselor to talk to, no school authorities, no parent. That's the scenario we're here. He held them. The only thing we have recently is she went to a doctor. The doctor said, report it. And I've attached the doctor's statement to that effect. She followed what the doctor said. When CPS said, follow the court order, she did. So she did exactly what was required except for 2 days. That's a proportionate response by her, does not indicate any.
The mother's attorney attempts to redirect the court by emphasizing recent conduct rather than historical allegations. It is a calculated legal approach because judges often give greater weight to current circumstances than older disputes.
Any psychological problem. What isn't proportionate is father with no emergency, because CPS didn't see any, refusing to follow what they said, refusing to follow what you said, pulling the kids away, pulling them out of school. I don't know what that has to do with anything except to keep them away from everybody. So it is, we've submitted photos to the friend of the court today and to counsel that show what appeared to be injuries. I could forward them to this court. I didn't want them in the court file. Huge red, purple circle on the child's, similar kind of injuries on the child's. It was a couple of days before she got into the Dr. Benjamin, but his recommendation was you are to go to the police. He made the report to CPS. I mean, that's the scenario. I don't see anything based upon that of any conduct in the last 8 months with these people for to suddenly say my client's acting psychologically inappropriately.
And Your Honor, I
Well,
just would
And the court
like
agree,
to
Mr.
point
President, the
out,
court's read the court has read the pleadings thoroughly from both sides. So I understand there's appropriate response by withholding of the parenting time for weekend, but no, not a long period of time. Both parties are at fault, but clearly there's a history here, which this court was not aware of till just recently on the part of Ms. Smith. And the most recent was manifested in this another January 2024 report. I agree, most of these allegations go back to July of 2023. But the court was not aware of some of these allegations. There's numerous witnesses that indicate that these children are being coached by mother. The professionals have concerns about mother's relationship with the children. And the protection service is very slow to act, So it's not surprising that they have not taken the action. The court sees no reason for psychological evaluation of Mr. Smith, but the court will order that be a psychological evaluation of Ms. Smith. I was hoping somebody, it doesn't have to be a physician, maybe a physician's assistant. Somebody that maybe, I don't know if Miss Tiemann does any private practice. Does she do any private practice, Miss Smith, or is she totally retired?
She's retired.
All right, maybe she can suggest someone to you. I'm really concerned about the continual. I mean, there's a pattern here. And back, yes, and I agree, Ms. Trangelo, a lot of these things are old. It doesn't provide the court for the basis right now to change custody or parenting time because they go back to, most go back to prior to this order of July 18, 2023, which the court recalls the parties agreed to. Dad's parenting time was every weekend, Friday 5 to Sunday 5, but there's a history here that's quite disturbing to this court.
and Your Honor, I mean, she just filed in February another police report, and they didn't attach, ironically enough, the full medical record as to why the doctor referred mom to make another CPS report. And that's because of mom's history of what happened. Mom is the one who stated that, which has improved. Mom developed suspicion of injury when she overheard the child talking with his 6-year-old sister, whispering. Mother stated she heard daughter state the father threatened to hurt them and for them not to tell anyone. Mother further stated the daughter stated father tied patient to a chair by the ankles and has given him.
Miss Olet, the court has read all of that. You don't need to recite to the court. Instead of read every pleading, every piece of paper that's been submitted, I've read. The court notes for the record, there are sexual complaints made by the plaintiff mother on October 2022, April of 2023, May of 2023, June of 2023, now again in January of 2024. So the court is inclined to adopt this recommendation. Parent time will continue. I'm going to set review dates, and then the court's going to order that Ms. Smith secure a psychological evaluation.
This portion becomes the hearing's major turning point because the court introduces a psychiatric evaluation for the mother. That decision is not presented as punishment, but as an investigative tool designed to answer questions the court believes remain unresolved.
And so mother's
I think
parenting time
whoever's going to
gets
do that
continue?
evaluation needs to be provided with all these reports. So Ms. Bertrandra, once she's identified a person that would do this, if you could inform Ms. Olet, the person who is going to do that evaluation, so Ms. Olet can transmit a copy of all these CPS reports and doctor's reports to that psychiatrist or the nurse practitioner psychiatrist. So they have the basis for this court's concern.
So can this be a psychologist or psychiatrist? You said psychological report. I wanted to be clear before I ever get somebody lined up.
Any thoughts, Mr. Pratt? Or again, I just know the reports that mother was previously was seeing a psychiatric nurse practitioner. So I think it's more of a psychiatric issue than a psychology issue. I'm looking for some suggestions, guidance, help.
Your Honor, I would think psychiatrist, it's been my history of knowledge that psychologists are more so medication when a patient needs medication. So if you want an actual diagnosis, you're probably going to want a psychiatric.
Okay. Ms. Olet, would you agree?
Yes, we would agree.
All right. So Mr. Bertrandra, to answer your question, be a psychiatric evaluation.
Your Honor, for the record, a week ago, the parties had a family meeting with CPS as well as Westland Police, and Attorney Olet was involved in that, which is part of the reason I made the recommendation I made. They did note, though, that mom needs to stop filing false allegations with CPS, so there has been involvement, Your Honor.
Okay. Is it possible they may seek a authorization of a complaint against mother? Is that still open and pending?
That's what we were told by the Westland Police Department.
Okay, remains to be seen.
Furthermore, CPS has already indicated that they are formulating another case against mom for medical abuse as well as mental abuse of the children for having them undergo all of these exams.
And if that comes to fruition, Ms. Olet, bring it to the court's attention. Again, the court's going to add to Ms. LaPrade, if you could add your recommendation to your recommended order, Ms. LaPrade, that the plaintiff mother secure a psychiatric evaluation as soon as possible. And the court, like I said, this for review. I don't know how long it's going to take. Perhaps you can assist her, Mr. Petrangelo, in identifying such a person. I was hoping this Ms. Tillman was still available. Ms. Tiemann is Tieman. Patricia.
Perhaps we could I don't know if we can reach her anymore if she's retired, to see if she would recommend someone. There's a few psychiatrists here in the community.
Okay, so perhaps Ms. Smith can reach out to her, see whether she's got any recommendations, and if so, Ms. Smith, pass any names on to Mr. Petrangelo. Mr. Petrangelo, if you would notify Ms. Olet once you know the identity of this person, whether it's a psychiatrist or a nurse practitioner. I think that would be sufficient. And the court's going to set this for review.
I would anticipate it's going to take, just first we have to identify someone, then she has to make an appointment and all that. It's going to take a few months before we'd have any information for the court, I assume.
Okay. All right, we'll set a review date in May. And Ms. Olet, if something comes to your attention about any charge being authorized against Ms. Smith, whether it's CPS or Westland Police Department, bring it to the court's attention. You can always notice this on, and we're pretty good at giving relatively quick hearing dates.
Yes,
so we'll set this for review and sometime in May.
Children go through again another actual exam.
Well, yes, the court, I'm reluctant to order that this child not submit this minor daughter not be submitted to another SANE exam, but Mr. Pratt, what's your thoughts on it? This child went through 3 SANE exams within, I believe, a period of 3 or 4 months. I mean, that's traumatic. And there's some comment that the doctor was concerned about her emotional well-being.
The recommendation from the referee adds another layer that strengthens the court's concerns. Instead of relying solely on past reports, the judge now hears that recent meetings with child protective authorities and law enforcement allegedly included warnings about repeated false allegations.
But I'm reluctant as a court to simply prohibit the parties from securing such an exam. I would just strongly warn Ms. Smith, you better have some pretty strong documentation before you just submit your daughter to another exam. It's very traumatic for a 6-year-old. Mr. Pratt, your thoughts on that?
Your Honor, I think that an order barring that would probably be contrary to what this court is attempting to do, but I would just strongly, I'm a firm believer in reminding people of fairy tales and the boy that cried wolf. So we just need to be cognizant that we're being honest when these things are happening, rather than and again, the police said no more false allegations. So it's brought to the police's attention, Your Honor. So if we could curtail that, maybe we could get back on track.
The problem is the kids keep undergoing these exams, and I feel there's no intervention.
Well, that's maybe CPS, push CPS. CPS is very slow to respond, Ms. Lett, and I understand that, but I think hopefully Ms. Smith heard the comments of Mr. Pratt. You better make sure that they're accurate and you're not making any false allegations, Ms. Smith, because that could result in a loss of custody if there's another occurrence. In any event, Mr. Petrangelo, Ms. Olet, do I have May 21st or May 22nd? And obviously, if Ms. Smith takes her to the hospital, Dad needs to be notified immediately, so Dad can go over to the hospital. You got joint legal custody. Miss Smith, you need to immediately notify dad on your way to the hospital before you arrive there that you're heading over there. If you take either of your children to the doctor or hospital, you need to notify dad. Is that understood?
Yes.
And so Mr. Smith can respond immediately and be at the hospital. And he can provide input to the medical staff. So May 21st and May 22nd, Miss Olette, Mr. Petrangelo, that works with your schedules.
What time on both those days, Your Honor?
We got the number of dates available, the times available. On the 21st, we have 10 a.m. or 2:30. On the 22nd, we have 8:30 or 1:30.
The 10:30 date on the 21st would work, or the 1:30
That's
date
fine.
on the 22nd?
We'll take the earliest date because I don't want to see any more happen to these children. It's grotesque.
So what time on the 21st, Mr. Petrangelo?
I believe you said 10:30?
10 or 2:30. I'm sorry.
Oh, 10,
Earliest
well,
time.
either one on the 21st.
Okay. All right, 10 a.m. then. We'll put this
10 a.m.
review at May 21st, 10 a.m.
All right.
Miss Olette, Mr. Smith had a question. I don't know if you want to see what his question is.
Is there, I mean, so mom gets unsupervised, unfettered parenting time, that's correct?
The conversation about repeated forensic examinations reveals one of the hearing's most significant concerns. The judge avoids creating a rule that could discourage legitimate medical reporting, yet also refuses to ignore the emotional cost of unnecessary examinations.
Correct.
And no makeup time for the time she missed at this point? Or is there?
Well, again, we can reserve that. Do you want to talk about that?
I at this point, I'm fine with reserving it. I guess after the court has more information after this evaluation.
Yeah, the court's probably not inclined to grant makeup parenting time, Mr. Petrangelo. Obviously, with Mr. Smith, yes, he should have petitioned the court, but he can't do that overnight. He acted out of trying to protect the children for another medical exam. So yeah, at this point in time, not going to reserve that. Of course, not going to give mother any makeup parenting time.
I would just, and I don't care if it has to be in an order, Your Honor, but this idea of pulling the kids out of school to, I don't see how that relates to anything that happened here that was appropriate. School issued a truancy notice. We just want to be sure nobody's going to do that again.
It was
Right.
wholly appropriate because dad was withholding so that the children wouldn't have to continue to go through sexual exams. In fact, the school
haven't.
worked with dad.
That's a
The school worked
misrepresentation.
with dad. It is not a misrepresentation. We have lots of documentation. The school worked with dad to get the children out of school because mom was coming up there to pick them up. So the school is aware of what is going on with mom.
I don't know why the school would issue a truancy letter then, if that's the case, and which I attached. And certainly this, I mean, there was no exam or anything like that, no sane exam in this. All that occurred before last July.
All right, that's all noted for the record. And obviously, what I understand is we have just a first grader, 6-year-old. So it's we're not in the middle of high school final exams or anything. So yes, the court agrees the child should be attending school, but I understand obviously if the child went to school, mom could have swooped up the children. Let's just move forward and review this matter on May 21st at 10 a.m. Miss Smith, reach out to Miss Tiemann and see if she can recommend an individual to the psychiatric evaluation so we can get that done. Let Mr. Petrangelo know the name of that person. All right. Anything further, Mr. Petrangelo or Ms. Olette?
No, Your Honor.
Okay, so what did the parties exchange for parenting time?
On Fridays.
Friday at 5.
Right, but where do they conduct the exchanges?
Oh, where? Where is it?
At a guess, it's a middle point.
Okay, so that's been the exchange point in the past. So if so, I want to make sure everyone's on the same page, and they will continue to use that same exchange point.
As the hearing moves toward procedural matters, the judge quietly establishes new expectations that could significantly influence future proceedings. Requiring immediate notification before any hospital or medical visit reinforces the concept of joint legal custody in practical terms, not just on paper. It removes opportunities for one parent to control information while giving both parents equal access to medical decisions. The hearing concludes without the dramatic custody change either side may have anticipated, but the outcome still carries serious implications. Parenting time remains in place, exchanges continue under existing procedures, and the immediate legal framework stays intact. Yet the judge leaves both parents with unmistakable warnings that extend far beyond this single hearing. The mother's future credibility now depends heavily on the upcoming psychiatric evaluation and any additional reports that emerge from law enforcement or child protective authorities. The father, meanwhile, is reminded that acting independently, even with protective intentions, is not a substitute for court approval. Instead of declaring a winner, the court creates a roadmap for future decisions based on evidence gathered after this hearing. That approach reflects a broader judicial philosophy. Lasting custody decisions should be driven by verified facts, professional evaluations, and the children's long-term welfare rather than the intensity of either parent's accusations.